Good afternoon, everyone. Thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and this is the third, could be the fourth, third or fourth in our six-part series. We call them Zoomside chats that came out of uh, like the fireside chats. We call them Zoomside chats. They came out of the COVID. During COVID, we weren't able to give seminars, so we developed this on a six-part series, and it was well received. So we're repeating it from time to time. So today we're going to talk about Medicaid asset protection strategies. A number of you sent in questions. I'm going to be happy to answer them at the end. There's a feature where you can type in your questions while I'm giving the presentation. And although I can't answer those while I'm presenting, I'll be happy to answer them at the end as well. So feel free to ask questions as we're going along. Ettinger Law Firm's website is trustlaw.com. Some of you may know it's also ettingerplan.com, same website. And there's our staff. And you'll see to my left on the screen is my lovely wife and law partner, Suzanne Ettinger. And our practice is limited to trusts and estates, wills and probate, estate tax saving strategies. I can save you income tax. I can save you capital gains tax, but I can especially help you save estate tax. And Medicaid applications, Medicaid asset protection trusts, etc. We have two offices in Nassau County, one where I am today, which is Rockville Center, and also in Lake Success on Marcus Avenue. In Suffolk, we have three offices. We have one in Melville at the Huntington Quadrangle. We have one in Islandia on Motor Parkway, and we're in the village of Huntington, where Suzanne and I reside. Staten Island, we're at 900 South Avenue. Westchester, 140 Grand Street, right in White Plains. Rockland, we're in New City, 245 North Main Street. Orange County, we're next to Orange Urgent Care and Crystal Run. Big building there, big office building next to the police barracks. Dutchess, we're in Rhinebeck and Fishkill, been there for many, many years. And in Albany, right there on Wolf Road, been there for more than 35 years. So with that, let's get started. Strategy one, caregiver agreements. This is where a family member is taking care of another family member. And this caregiver agreement is actually known by Medicaid as a personal services contract. So if somebody taking care of you and you have a contract for them to take care of you, it's not a gift that has to be, that gets penalized. It's compensation. You're performing a service, they're paying a bill. There's no penalty for Medicaid for what you pay under a personal services contract. But these agreements are scrutinized. They have specific rules for them to be valid. So they have to detail the services to be performed, bathing, washing, dressing, showering, preparing meals, cleaning, shopping, all those things. And there's a sort of flexible going rate in each county for what the county will accept. It can be 4,000 or 5,000 a month, depending on what the services are. Is it their house or is it your house? If there's room and board at your house, plus meals, plus shopping, plus everything else, obviously a higher rate. So first, you're going to need to prove that the service was needed. And so you have to get a note from the doctor stating that so-and-so needs help with the following issues, and it should list pretty much what you're doing under the caregiver agreement. Tricky. You want to make sure the other family members are on board. You don't want them coming back and later saying, "Oh, mom paid you, 4,000 or 5,000 a month. You should have done that out of love and affection." If it was us, we wouldn't have charged her. All kinds of things come up, as you can imagine. So we want to make sure they're on board and they agree to this. Sometimes we even have them sign on the agreement, so there's no question. So it can be care, as I said earlier, or care plus room and board at your house or their house. Now, because you're getting paid for a service, this is considered income to the caregiver, and it's a medical deduction for the person who's paying. So you're going to pay income tax on it, so factor that in. So the caregiver agreement works, in obviously those circumstances where you have money you're trying to protect, and the person may have taken time off work or quit their job to be the caregiver, so they need to be adequately compensated. The second strategy is the pooled income trust. This trust is designed, it's actually a New York State creature, and the state certifies these trusts, they're really trust companies, for you to pay your income into so as to qualify for Medicaid for home care, called community-based care. So for community-based care, home care, you an individual can keep about $1,800 a month and a couple about $4,000 a month. So what if you're over that amount? In order to allow you to stay in your own home, we have this very strange system in New York where you open an account with the pooled income trust. They have various different names, but they all do the same thing. You send them your bills, you send them your income, and as long as you have bills to cover the income, whatever you can expense out doesn't count towards the amount you can keep. So let's say your income is $5,800 a month. Make it simple. You're single. Your income is $5,800 a month. You're only allowed to keep $1,800. But if you have $4,000 in bills, you send those bills to the pooled income trust. You the pooled income trust, you send them a check for $4,000, right? The $5,800 less the $1,800 you can keep. Send them a check for $4,000, bills for $4,000. They pay those bills. That $4,000 is not counted as your income if it goes through the pooled income trust, and it gets expensed out. I know, very strange, isn't it? So the reason for this system is to allow you to be able to stay in your own home, because if you had to use your income for your care, you'd have nothing left to pay for the mortgage, utilities, repairs, improvements, all those things. So the state allows you to send your excess income, as I said, to the pooled income trust. You send their bills, they pay them. Interesting, but it works. So this is going to allow us to age in place by paying our rent, mortgage, utilities, insurances, and enable us to stay in our own home. Now, you may have heard they keep talking about a new 2.5-year look back to qualify for home care or community-based care. That has not passed. We don't know if and when it will pass, but we're wary of it. We want to protect our assets sooner rather than later in case they do pass it. The can keeps getting kicked down the road. This has been going on for about 3 years now. So we really don't know. I don't see anything on the horizon, but we're aware of it. Right now, you can get Medicaid for home care by moving your assets in the 1 month and the next month applying. So there's no look back for home care currently. So as far as the assets you're allowed to keep, an individual can keep 32,000. We know there's a 1 month look back on asset transfers. So if you're over 32, you move the assets. Next month, you apply for Medicaid, like a walk in the park. There's a possibility, we said, of the new look back, which is 30 months. And even when it starts, it's going to be phased in by adding a 1 month look back each month until 2.5 years has passed. I know that's confusing, but what it means is it'll actually take 2.5 years for the 2.5-year look back to become fully implemented, because when they started, they're going to start with a 1 month look back. After 2 months after they started, it'll be a 2 month look back. I know, again, very strange. So what makes you qualified for community-based care is you have to be unable to perform any 2 or more of the ADLs, the activities of daily living. Those are bathing, dressing, cooking, feeding, walking, toileting, showering, the whole list. So that is now changed actually from 2 to 3, and except if you have a cognitive problem. If you have Alzheimer's, dementia, then it's only one activity daily living required. So, you know, you really have to be quite infirm to get Medicaid these days, but there are a lot of people in that situation. They're changing the law so that instead of your treating physician, they're going to replace it by a bureaucratic functionary called a qualified independent physician approved by the Department of Health for a course of treatment. This is right out of the statute. Of course, it just makes things more complicated. But the bottom line on this is that the need for the Medicaid Asset Protection Trust has increased exponentially because nobody wants to get caught with a 2.5-year look back for home care, can't afford to stay on their own home because their income is not, their assets are not protected. Nobody wants to go in and spend their assets for 2.5 years for home care. It can basically wipe a lot of families out. So we know the Medicaid Asset Protection Trust protects us from nursing homes. That's a 5-year look back. But now we're going to also be looking to protect our assets. We can afford to stay in our own home. That's changed the landscape quite a bit. So strategy 2, again, the pooled income trust. Protect your income, the assets you can move. There's only a 1-month look back, and protect your income and be able to afford to stay in your own home. Another strategy, of course, is long-term care insurance. Let's look at that. There's actually 3 major reasons why people can't get long-term care insurance. One, they can't afford it. 2, they don't qualify for medical reasons. And 3, a lack of trust. People just don't trust the insurance companies to pay when they need the care. There have been a few cases where the insurance company have gotten some negative publicity, but generally they do pay. But if you can't afford it, or you can't get it for medical reasons, you're going to have other options, primarily the Medicaid Asset Protection Trust. But we know the long-term care will pay for home care or facility care. A lot of them these days, the more modern ones, are cash pay policies. If you need the benefit, they give you the $200 or $300 or $400 a day, and you pay whoever you want, including a family member. But how much do you need depends on a number of factors. So your daily benefit, which is how much they'll pay a day, plus how many years you want it for, and the elimination period, which is similar to a deductible on a property or casualty insurance. The elimination period is the time before which they have to pay. People generally will take a 90-day elimination period, which means I'll pay the first 90 days myself, and then it kicks in after that. The longer you make the elimination period, the less the premium is, because there's a less chance that the company's going to have to pay. And if they do have to pay, there's less they're going to have to pay. But you need at least a 90, 100-day elimination period to make the policy affordable. And, you know, you're not really concerned about paying the first 3 months. You're worried about paying for years. So this helps keep your premium down, which is not a bad idea because you may never use the policy, right? So we want to try to keep the cost down. So we want to look at the daily benefit. How much will they pay a day? And first, we want to look at your income from all sources, from your pension, your Social Security, required minimum distribution on your retirement plans, interest on your investments, dividends on your investments. Add up all your income, and then you could subtract that from the cost of care. So let's say your income is $10,000 a month, and the cost of care is $20,000 a month. So you need insurance for the $10,000 a month you're short. Once your income and insurance is enough to pay the cost of care, you don't have to worry about your assets because Medicaid is not going to come after them because you don't owe Medicaid any money. You paid the bill. Actually, you're private pay. So Medicaid doesn't even come into the picture. So this requires, the little chat with the elder law attorney to go over how much you need. And then there's riders for inflation. You can get a simple 3%, a simple 5%, you get compound 3%, compound 5%. What's the difference? It depends how old you are and if your income is going to go up or stay the same. We can figure all that out together, not too difficult. We do have people in New York who have something called the partnership policy, which was a partnership between New York State and the insurance companies, where the state agreed that if you buy this partnership policy, they will not go after your assets after you're gone. They'll still take your income. But if your income is not enough to pay for the cost of care, they're not going to go after your assets. The state will pick up anything over your income. Those are good policies to have if you can get one. Now, we recommend sometimes the hybrid approach, which is to keep the cost of long-term care insurance down. You might want to get enough to pay for home care so you control the home care, even maybe have a family member help you out that way. Use the MAPT protect assets from nursing home costs. So I want the flexibility to have my own insurance for home care because I want to be able to stay in my own home and control the situation. I don't want to be subject to the Medicaid program in my own home and use the trust to protect assets of nursing home because at that point, I don't mind using the trust to protect my assets because I'm in a facility. So this hybrid approach works for some people. It's not a bad idea. Our fourth strategy, veterans benefits for caregivers. Well, the VA pays for service-connected compensation regardless of need, but very few people are in a nursing facility because it's service-related. They generally performed the service a long time ago, and now they have problems that are not at all related to their service. You have to prove that you need a service with a physician's letter, and this is for the veterans benefits. There's income and resource limitations. They keep changing all the time. But if you qualify, last time I looked, it was about 80,000. You have to have under 80. But it pays about $36.50 a month these days for the veteran. And if it's the spouse of the veteran, about half of that. This is called aid in attendance, and this is to help with home care. Now, it's a funny program. You file for it through the Veterans Administration or your local office for the aging, and 2 years later, they send you a check for 2 years worth of these payments because they're so far behind. As I said, lawyers don't apply. You have to apply yourself. Lawyers are actually not allowed to apply or charge a fee for this. So you do it yourself. So going back, if you're a veteran, you're able to get aid in attendance. If you need it at home, you can get the benefit from the VA. Now we want to talk about Medicaid exempt assets. Again, if you joined us late, you can type in your questions at the bottom. We'll answer them at the end. Anybody who sent in questions ahead of time will also answer those. Now we're on our Medicaid exemptions. Your house is exempt up to about 1.1 million of equity if you have a spouse living there. So you have to have a spouse to get the exemption for the house. If you don't have a spouse, the house is not exempt at all. If you have a spouse, the spouse can keep up to maybe 160,000. Okay. If you don't have a spouse, you're allowed to keep 32,000. When I say keep, what happens to the excess? It has to be spent on your care before you qualify for Medicaid. So let's take a moment and explain the difference between Medicare and Medicaid. Medicare, we know, is for health insurance. Everybody gets it at age 65, regardless of need. But Medicare is for skilled care, doctors, hospitals, nurses. Medicaid is for what's called custodial care, help with washing, dressing, showering, etc. Now, the Medicaid program, you don't automatically get when you're 65. It's called a needs-based program. You have to need the benefit, which means you have to qualify. Either you don't have assets or you sheltered your assets ahead of time in a Medicaid asset protection trust. The community spouse can keep one car. You can keep any kind of car, so if your car is in bad shape, you can buy a new car, sell that, get a new car, and you get to keep more assets. You can prepay funeral and burial for all family members, immediate family, which is sons and daughters, parents, and their spouses, and includes stepdaughters, stepsons, and their spouses too. So you can actually prepay an awful lot of funeral and burials if you like to, or you want to make money disappear. They don't go after your personal effects, your furniture. You get to keep that. IRAs and 401ks, 403b, 457. All these tax deferred plans, today they're deferred to age 73, are exempt from Medicaid. They can't go into your IRA. They can't go into your 401k. They do get the required minimum distribution. Why? Because that's income. They can't go after the asset, but they're entitled to the income. So you have to take it out. IRS makes you take it out, and then Medicaid grabs it. An annuity with your spouse as a beneficiary is an exempt asset. And anything you put in my Medicaid asset protection trust for more than 5 years also exempt. What if you set up the trust 4 years later? You have to go into a nursing home. You only have to pay for the 1 year that's left. So it always pays to get started, even if you don't make the 5 years. Assets in a third-party trust. Well, if somebody left you money in a trust, not a spouse, but if somebody else left you money in a trust, that's exempt from Medicaid because it's essentially somebody else's money. You can make money disappear, even on the nursing home doorstep, if you have a child who has special needs, son or daughter, as long as they're under 65, anything you put in a special needs trust for a disabled child is exempt from Medicaid. Let's see what else we have. Repairs and improvements for the home, exempt. Paying off a mortgage. Well, that's exempt because when you pay off a mortgage, it's not a gift. You're actually paying a bill. It's money you owe. So paying off a mortgage, no penalty for that. The primary caregiver rule. So if you have an adult child who's been living in the house with you for 2 or more years, immediately before you needed the care, the house is an exempt asset, provided it's transferred to that child. Now, what's caregiving? It's very liberal. If they've been living in the house for 2 years, it's assumed that they've been helping out. If you have a brother or sister who lived in the home for at least a year and you transfer to them, it's also protected. That's unusual. It happens, but it's not that often. Income exemptions for the community spouse. The $1,800 that the community spouse can keep. Strategy 6, MQAs, the Medicaid qualifying annuity. So let's say you're 85 years old, you have to go into a nursing home, and you're over the $32,000 limit. You buy an annuity with the money over, let's say you're over by $300,000. So you buy a $300,000 annuity. It has to be payable to you over your life expectancy. So I'm going to say the life expectancy on an 85-year-old might be about 6 years. So it has to pay back over 6 years. But very often when somebody's going to a nursing home, their life expectancy according to the tables is much longer than their actual life expectancy because they're really quite ill. They're going to a nursing facility. So they might live only a few months or a year or two. So when you stretch it out to 6 years, if you die within a year or two, the family gets the 4 years that are left. So it's a way to maybe get some of that money back. So it has to be paid in full within your actuarial life expectancy, so it's not a gift. Those payments, first of all, are going to be much less than the nursing home costs, right? Because nursing home cost can cost $20,000 a month. So they can't get $20,000 a month from the $300,000 you're over. They can only get the annuity payments, which are going to be much less. If you live the 6 years, they'll get everything because it's a 6-year payout, but generally there'll be something left for the family. The unleft balance will go to the beneficiaries, your heirs. Spousal refusal. We only have that in New York and Florida, I believe now. Only 2 states allow spousal refusal. So this is an interesting strategy. The community spouse, we know, can keep about $4,000 a month in income and maybe up to $160,000 in assets. And that's an outdated slide. Home up to about 1.1 million and an automobile. So if you have more than this assets, more than this amount, you can shift all these excess assets to the community spouse. That's one living in the house. Community spouse then signs a document. It's called the spousal refusal, saying, I need these income and assets for myself. I can't afford to contribute to my spouse's care. By law, the county has to give the spouse, the ill spouse, Medicaid benefits. They can make a claim against the community spouse for support. They can come after him or her, but there's lots of reasons they don't come after. One is a lot of these cases fall through the cracks. The county decides there's not enough money to pursue. Other things happen. So they may never make the claim, as I said. But when they do make the claim, they're claiming the Medicaid reimbursement rate. That might be a full 1/3 less than the Medicaid rate. Than the private pay rate. Let's say the private pay rate in a facility is $18,000 a month. Medicaid's going to pay that facility $12,000 a month. And when Medicaid comes after you, they can only come after what they paid, which is the 12. So you start off getting a 1/3 discount, and that's a lot of money. And you can negotiate how much you owe the county. And I've had cases where I got the county to hold off until after the second spouse died, with the county attorney telling me, well, they're not worried. The county's going to be around for a long time. So that may be a strategy if you have a spouse. The gift and loan strategy is for people who don't have a spouse. Let's say you're over by 300,000. You don't have a spouse. You don't want to lose that 300,000. So you can do this with a client on the nursing home doorstep or already in a facility. And here's how it works. A simple example. Let's say the nursing home costs $15,000 a month, and the client has 300,000 in excess resources over the 32. What they do here is they lend the children 150,000 and then give them 150,000. We apply for Medicaid. Medicaid says, well, okay, I'm getting a little ahead of myself. So the loan gets paid back in 10 months at 15,000 a month, together with a little bit of interest. When you apply to Medicaid, they're going to say, oh, wait a minute, you made a gift of 150,000. There's a 10-month penalty. But remember, you're giving back the loan in the 10 months at 15,000 a month. So you use the loan repayments to pay for the penalty period. Let's go over that again. You have 300,000 over. Lend the children 150, gift them 150. Pay back the loan in 10 months at 15,000 a month together with interest. The kids do this. Now you apply for Medicaid. They say there was a gift of 150,000. The loan is not a gift. It doesn't count. There's a gift of 150,000. You could have paid for 10 months. We're giving you a 10-month penalty for the gift you made, because that's how long you could have paid. At 15,000 a month, you could have paid for 10 months with a $150,000 gift. And now we're using the loan repayments for the 10 months we can't get Medicaid. We're paying Medicaid with the loan repayments. I hope you're able to understand that. It works perfectly. You end up saving half. And now we get to the granddaddy of them all, the famous, wonderful Medicaid Asset Protection Trust. Somebody asked me in the questions how long it's been in existence. Well, when I started in 91, it was already there. So it's already 35 plus years. So here, you name one or more of your adult children as trustees. You limit yourself to the income only. If you don't need the income, you could do no income trust, but generally people will want the income. What's the income? Interest, dividends. It makes sense for assets you're not going to spend, like your home. Protect your home. You'll see the trust can sell the house. There's no downside. Money's paid to the trust. A trust can buy a smaller home, a condo, can invest the money, pay you out the income. And also, not only just the home, but you have investments you're not spending. If you're not spending it, then you're safe keeping it for the long-term care industry. Doesn't it make more sense to put in that trust, still there if you need it, but somebody else can't come and take it away from you? We know there's a 5-year look back for facility care. I mentioned earlier, you put the money in, you have to go into nursing home in 4 years. The trust still works. You only have to pay for the 1 year that's left. You already got 4. We know the 2.5-year look back is coming for home care. We just don't know when. So that was a quickie on the Medicaid Asset Protection Trust. Now, if you want a full seminar on the Medicaid Asset Protection Trust, search Ettinger Law on YouTube, and you can watch my full seminar just on the Medicaid Asset Protection Trust. So once a month, I give my full seminar on using trust called 4 Advantages of Using Trust. You register at trustlaw.com. Obviously, you can see it's on August 6th. I do it in the evening. And you don't even actually have to watch it live, because if you register, you'll get the recording the next day. So take advantage of that. That seminar, I've been giving that seminar since, well, I gave it for over 30 years until COVID hit. I stopped giving it, but I put it online so that anybody could watch it anytime. So a little bit about our unique planning process. That's my new book, Ettinger Law Firm's Guide to Protecting Your Future, 2025 edition. But the process begun with the seminar. So now you know a little bit. We offer a no-cost initial consultation. We review your existing plan. That's not only for legal, but also personal. Is it legally adequate? Are there any pitfalls in there that you're not aware of? Usually there are. We'll see if that's still your wishes, who you want in charge, who you want to leave it to, et cetera. We're going to give you a free copy of my book and advise you which chapters apply to your situation. Maybe an hour and a half of reading, but we like to build your confidence. So I believe estate planning is a confidence building exercise. Everybody who comes to see us is low confidence because they just don't know that much about it. So I have videos for you to watch. I have my book, which I wrote in plain English. You don't have to read the whole book, just the chapters apply to you. And you'll come back for a second meeting, you'll have more confidence. Right in the first meeting, though, we're gonna assess your situation and tell you what the fees will be, because people like to know. But part of the first meeting is the second meeting, where you come for a second no-cost consultation to answer any questions you have from what you read or what you watched on YouTube. And maybe we gave you things to think about from the first meeting. You thought about them, you have some answers. So come in for that second consultation. We answer any questions you have. We draft the estate plan together with you. Who do you want in charge for legal? Who do you want in charge for medical? Who do you want in charge of your estate after you're gone? Who do you want to handle your affairs if you become disabled? How do you want the estate distributed? All at once or over time? Equal shares, unequal shares? Lots to talk about. And you'll have our input from 35 years experience, which will help make the thing hold together better. So at the end of that second meeting, you get a detailed 3-page written proposal for the fees quoted. We mentioned it the first time, now it's in writing. And now you decide if you want to go ahead. And unique among law firms, we don't have you sign anything, no retainer agreement. We give you an agreement, but we sign it, you don't sign. Our agreement says we're going to go ahead on your say so. No fees are due until after documents are signed. Why do we do that? Keep you in control. You're in control the whole time. You don't pay anything unless you're satisfied. Obviously, the best place for you to be, and we feel if that's the best place for you to be, and we're here to serve you, then that's the best place for us to be. And then we'll have a final meeting. The third time you come in, review and sign documents. And we accept credit cards. You can pay it all at once. You can do it in 3 month installments. Today, most people are paying by check because we had to add that 3% charge for the credit card because they're killing us, the credit card companies. Now, once you sign, we don't say goodbye. The Standard in New York, thank you very much, goodbye. Never hear from them again. We say welcome to the firm. We trademark the process, keep you up to date with law changes and other matters through our weekly Ettinger Elder Alert, comes by email. We call you in for a free review every 3 years to see any changes in your health, assets, family, births, deaths, marriage, divorces. We don't charge for phone calls or emails or questions. This way, you can always get answers, and they're correct answers, which is hard to get today. So you basically have us on retainer, even though you've already paid for the rest of your life. But the point is, by using this program, your plan is never more than 3 years old. It's designed to work when you need it, not when you signed it, probably decades earlier. So if you'd like to see me or one of our, Suzanne, my wife and law partner, one of our experienced associates, everybody does things the same way here. Be in good hands with any of us, I believe. So you could do it in office, by video, by phone. There's the phone number to make the appointment. Or you can visit us at ettingerplan.com or trustlaw.com. It's the same website. You know, we look forward to doing that. I think that it's more valuable to you to come in person, but I understand not everybody can come for various reasons. So video is available, Zoom, and if you're not that tech savvy, you can even do it by phone. So now we're going to go to the questions. Let's see what questions we have here. Allow me. Okay, we have a few questions. Robert says, who verifies that the terms of an irrevocable trust are carried out correctly? Well, nobody verifies it. You pick somebody you trust, and your beneficiaries can hold their feet to the fire or call them accountable if they're not performing. But there's no outside source. It's private, and you pick somebody who you trust, or you can pick two people, say either of them can act, but they watch each other. They have to keep each other informed. Anonymous says, is there a formula you can apply to determine the likelihood you'll need Medicaid and therefore the benefit of a Medicaid asset protection trust? Yes, actually. You know, you figure the cost of care in your community. Let's say a common number is $20,000 a month now. You look at your income, see if you have any long-term care insurance. And if your income is $8,000 a month and the cost of care is $20,000 a month, they're going to be coming off your assets for the $12,000 a month you're short. So we're going to look at your income, your assets, and see if you're exposed to the cost of care. Gail and Paul ask, should trust be named as beneficiary of IRA? Well, it depends. If you have a spouse, you want the spouse to be first because the spouse can execute a rollover and it becomes their IRA for their lifetime. You name the trust when you want it to go to the heirs, and the trust, it pays out over 10 years, whether you leave it to the trust or the heirs directly. You have under the Secure Act, you have the 10-year stretch. Feel free to add any questions while I'm answering the ones that came in ahead of time. Somebody asked, this is Jim asked, if you have a residence in New York and North Carolina, do you need separate trust? No, we can deed the property from all 50 states into your trust, Jim. Lenore, Patricia asks, how long has the MAPT, the trust, been in existence? At least since I started over 35 years ago. We have Diane asks, they want to sell their restored historic home, and they're concerned that it be sold at the proper time by the trust. Can the trust do this? Yes. You can put provisions in the trust for the terms of selling the property. Frank asks, he lives in Massachusetts. Can advise me in your state instead of New York? No, you need a Massachusetts lawyer. But if you're living in New York and you move to Massachusetts, not a problem. The trust is still good. But to find an elder law attorney near you, Frank, if you're listening, write this down. go to naela.org, the website of the National Academy of Elder Law Attorneys, and you can search for attorneys by zip code, elder law attorneys. So that's naela.org, National Academy Elder Law Attorneys. Pat says, they have a trust which only has a house in it. Do we need a Medicaid trust? Yes, because the house is not protective. It's a revocable trust. If you have a couple and it's in the trust really just continues until the second one dies. Can we put a mortgage can we put a house that has a mortgage on it in a revocable trust? Yes, federal law allows you to do that. You don't even have to inform the insurance company. Steve says, I have several buildings, some businesses, as well as investment accounts. How does Medicaid asset strategy planning change with more complex estates? Will an MAPT work? It'll probably work. It'll be to avoid probate, protect your personal residence. Any business assets are exempt from Medicaid. Income producing assets are also exempt from Medicaid because Medicaid contents themselves with taking the income. And when I say the income, it's the net income after expenses. Gail and Paul again. What is the benefit and drawback to put title of primary home in a trust? I don't know of any drawback. It's only a benefit. It protects your home, avoids probate, doesn't hold you back in any way. You can sell the house, as I said earlier. The spouse only need, unless you're over 7.2 million, you only need one trust. Because if you're over 7.2 million, you need two trusts to save estate taxes. Essentially, if you're over that's a New York State estate tax, not the federal. New York taxes estates amount to over 7,160,000. If you're under that, you can get by with one trust. If you're over that and you set up two trusts, you can claim two exemptions, one for the husband, one for the wife, pass over 14 million tax-free. That looks like about it for now. So thank you for joining, and thank you for listening. Wish you all a good afternoon and an enjoyable rest of the summer if I don't see you again. And again, thank you for coming. This is Michael Ettinger wishing you all a good afternoon.